You're watching The Legal Breakdown. So we've got the first day of the actual trial on the books for Donald Trump in Manhattan. This is his first criminal trial, so we're going to cover that right now. But first, just for those watching, Glenn and I will be covering the entirety of the Trump trial happening right now in Manhattan. So if you want to follow along with our coverage, which will be brief and right to the point, please subscribe to both of our channels. I'll put the links on this screen and also in the post description of this video. Okay, so Glenn, day one is done. What did we learn from today?
You know, what we learned, Brian, is the prosecution opened strong. As we've been predicting all along, the evidence against Donald Trump is considerable. I would go so far as to call it mountainous. It's very strong. And what we also learned is that the defense doesn't seem to have brought much to the jurors' attention that is concrete, that undercuts the quality, the strength, or the quantity of the incriminating evidence that Alvin Bragg and his team of prosecutors have amassed against Donald Trump. And we'll talk in a few minutes about some of the highlights, maybe more accurately, lowlights of some of what the defense opened on. But what I took away from reading all of the accounts, many of them coming out of the courtroom in real time, is it was a very strong, solid, and persuasive opening statement by the prosecution. And it looks like the defense has an uphill climb if they're going to be able to persuade the jurors that there really is some reasonable doubt, some significant weakness or shortfall in the prosecution's case.
So was today essentially opening statements that would outline what both the prosecutors and the defense are going to focus on moving forward?
Yes, opening statements are in essence a roadmap that the parties, the lawyers, give to the jury regarding what they expect the evidence to prove. You know, now, when the prosecutors open, basically they try to accomplish three things. They obviously highlight the incriminating evidence. They front the weaknesses in their case. We call that drawing the sting. The reason we do that is because the last thing any prosecutor ever wants to hear a defense attorney open on is, let me tell you what the prosecution didn't tell you. Michael Cohen is a convicted felon and a liar. So that's why the prosecution fronts that evidence, but then talks about all of the corroboration that supports and affirms everything Michael Cohen will testify about. So we draw the sting, and then the last thing the prosecutors do in their opening is they want to build their credibility with the jurors. You want that jury to look at you, the prosecutor, as the voice of reason, as an honest broker of the facts and the law. And I've given so many opening statements, Brian, in my 30 years as a prosecutor. It's funny because you watch the faces of the jurors when you begin to talk about the weaknesses in your case, and you can see the wheels turning. They're like, wait a minute, this guy's trying to prove his case beyond a reasonable doubt, but he's telling us about the weaknesses. What does it do? It gives the jurors a comfort level that you're going to bring them the case, the good, the bad, and the ugly, warts and all, and you're going to explain why those weaknesses are really not that significant because you've got corroboration. And ultimately, you know, I didn't pick, as the prosecutor, I didn't pick Michael Cohen as a witness. You know who picked Michael Cohen as a witness? Donald Trump, his co-conspirator, when he entered into this corrupt scheme to falsify business records, to cover up hush money payments, to gain unfair advantage in this in the 2016 presidential election.
Now, Trump has been going around saying that, you know, this is outside of court, saying that he paid Michael Cohen for legal services and that he has the total right to do that. Why is that a lie?
Well, first of all, Donald Trump does have a complete right to pay Michael Cohen for legal services. Here's the problem. He wasn't paying him for legal services. He was reimbursing Michael Cohen because Michael Cohen, Donald Trump, Alan Weisselberg, the chief financial officer, and David Pecker, you can't make that name up, who is the head of AMI, American Media Incorporated, which runs the National Enquirer tabloid. They entered into an agreement, a conspiracy, a criminal agreement to try to catch and kill stories, pay to cover up damaging information about Donald Trump, and interestingly, also to run what were false stories about Donald Trump's political opponents. Remember how Ted Cruz's dad was apparently in league with the JFK assassin? Yes, that was a product of the National Enquirer. They entered into this criminal agreement. And as part of the criminal agreement, the conspiracy, Michael Cohen paid Stormy Daniels $130,000 out of his own funds, and then Donald Trump had to pay him back. Really interesting part of the opening statement today was that part of this arrangement was that Michael Cohen got reimbursed the $130,000, but not just $130,000. He agreed with Alan Weisselberg that they would pad it. They would make it $420,000. Why? So they could disguise what was reimbursement payments and pretend that it was income for legal services rendered, which it absolutely wasn't. And they falsified business records 34 times over, each one being a 4-year felony under the laws of New York. So again, to recap, you ask, doesn't Donald Trump get to pay his lawyer for business expenses and legal fees? Of course he does, but that is not what was going on here.
Now, Trump's defense attorney had a line that stuck out at me, and I'm sure it's the same line that stuck out at you, and that line was, "There's nothing wrong with trying to influence an election. It's called democracy." What was your reaction hearing that?
Well, you know, it depends on how you define influence an election. If you define influence an election by knocking on doors, putting election campaign signs in your yard, and making stump speeches as a candidate, I'm with you. Nothing wrong with that. You're trying to influence the election. You're trying to win or have your candidate win. But, you know, there really is something wrong with violating the state laws of New York to try to cover up the fact that you are paying to suppress information that is directly relevant to your suitability to be a candidate, particularly a candidate for president of the United States. Hide that from the voters and then cover it up by creating false business records in violation of New York state law. You know, that kind of influencing an election actually constitutes a crime.
Glenn, there was another line from Trump's defense attorney that was also interesting. I'm going to read that. Quote, "Listen, use your common sense. We're New Yorkers. That's why we're here." Wouldn't common sense suggest the polar opposite? That a guy who clearly wanted to hide damaging information from the American people ahead of an imminent election would then commit campaign finance violations and subsequent falsification of business records to do exactly that?
Brian, that's a great catch. Here's the thing. I use a version of that line in every single case I have ever tried. You know what I say? I say, ladies and gentlemen, the good news is, as jurors, you don't check your common sense at the door. You bring it into the courtroom, you bring it into the jury box, and you sure bring it in to the deliberation room when you are given this case to decide. And when you apply your common sense to the evidence that you have seen develop during the course of this trial, you already know the conclusion that you're going to reach, and that is that Donald Trump committed these crimes and that he needs to be held accountable for his decision to commit these crimes. And common sense is one of the most important tools you're going to have in deciding this case.
And finally, let's cover this. This was the 4th day out of 5 that Donald Trump's been sitting in this courtroom in Manhattan that he's fallen asleep mid-trial. Can I get your thoughts on that?
You know, first of all, in fairness, lots of folks fall asleep during criminal trials. I've seen it happen over and over again in my career.
But how many of those people are engaged in a political campaign where their principal attack against their rival is that the other guy is sleepy?
Yeah, I mean, Sleepy Joe Biden, how about Drowsy Don the defendant? That's really what we should be talking about here. But what I was going to say is I've seen people fall asleep in the jury box. I've seen members of the audience fall asleep. I've even seen a judge doze off every now and then, and the judge's law clerk would give the judge a little nudge under the bench. What you usually don't see is the defendant fall asleep. That one is unusual. I've even seen an attorney or two fall asleep during the course of the trial day. So, Donald Trump is either, completely unconcerned with what's going on, but I'm guessing all of this is actually just taking a toll. Some of the people who were reporting from the courtroom said, Trump looks so tired, so haggard, so old, and he seems to be struggling to stay awake and struggling to sort of behave appropriately in other ways that I'm not going to go into. But I think Donald Trump it's all catching up with him, and it's not just his age, and it's not just a lack of sleep because he's posting incessantly at 2 a.m. about the witch hunt. I think this has got to be weighing on him because, Brian, nobody should forget, today was historic because it was the first opening statement ever in a criminal trial against a former president of the United States, but this is only the first of 4 criminal trials against a former president of the United States. So, you do have to wonder how much one man can take when all of his crimes have finally come home to roost.
Glenn, I don't want to get too psychological here, but I feel like for myself, if I was in Donald Trump's position, I don't know if I would ever sleep, much less sleep in the courtroom where my fate is being determined. Does it say anything about the guilt or innocence of a defendant when that person kind of is able to fall asleep in mid-trial when their own freedom is on the line?
Yeah, when things weigh on our minds, we generally have a hard time sleeping. When things weigh on our minds, like being falsely accused of a crime we didn't commit, I don't know that you could ever get any shut-eye at all.
Right.
There is this phenomenon, and I've heard police officers say that a defendant who's being interrogated, who's been arrested for a crime, is in an interrogation room, is being interrogated, and the detectives take a break, they walk out. Usually the cameras continue to run because these days we video all custodial interrogations, which is a good thing. A guilty man will fall asleep every time. But on those occasions when somebody has been arrested and it turns out that person is innocent, when they take a break in the interrogation and they walk out, you can actually see somebody who turns out to be innocent of what they're being accused of virtually bouncing off the interrogation room walls because they are so wound up and anxious about the fact that they're in a situation that they really don't deserve to be in. I don't know that it's a perfect parallel between those anecdotes and what we're seeing of Donald Trump, but I think there may be something to it.
And that's obviously something that the court staff and the attorneys would have some mindfulness of, but that isn't something that the jury would understand because these are all first-timers in a situation like this. Is that right?
Well, but we have 2 lawyers on the jury, and I've heard so much discussion over the last 48 hours or so from legal analysts, from trial lawyers included, about whether it's a good idea or a bad idea to have lawyers on the jury. I think most criminal litigators are of the opinion that they don't want lawyers on their juries. I had the opposite view when I was a prosecutor. I actually liked and had lawyers on my juries routinely because I didn't strike them. I didn't move to strike them. And it was because I actually got to talk to a number of them after the trial had concluded in my local prosecutions, not my federal prosecutions. I did both, and in federal court, you're not allowed to talk to the jurors after the trial is over, except with express permission of the judge. And I had these lawyers/jurors often tell me the same thing. Glenn, there were people in there that were really not following the judge's legal instructions that we are duty-bound to follow, and they would start sort of wildly speculating and spinning out of control about alternate theories that were not based in the evidence or the lack of evidence. So what I did as a lawyer who was abiding by the judge's instructions, I would bring them back to the judge's instructions. I'd say, let's review the instructions the judge gave us about how we are not to speculate, right? That's not what reasonable doubt is. It's not a speculative or fanciful doubt. That is precisely the language of the reasonable doubt instruction of law that the judge gives the juries. So I came to believe that lawyers on juries are generally a good thing.
Well, to that point, there was a list of all of the news sources. I believe it was the New York Times that compiled a list of all of the news sources where the jurors who'd been selected for this trial get their news. And one of the jurors, juror number 2, was the only one who got their news exclusively from Truth Social and from X. So didn't exactly bode well for somebody who's open to the truth. And that part actually worried me quite a bit. There was also one juror number 4, who got their news from 0 news sources. So everyone's like, hey, good on that person, just living your best life and unencumbered by having to read any news source. But for juror number 2, who only got their news from Truth Social and from X or Twitter, I was worried about that, but I'm presuming that you're going to say that this isn't really a worrisome moment for you because, to that exact point, there are lots of folks on the jury who can recognize, like, your personal preferences or affiliations or allegiances aside, if you're just going to focus on what the evidence presents in this case, that these people will be able to look beyond that.
Yeah, and here are a couple of thoughts about that juror. I saw that as well, and it piqued my interest. And all things being equal, I wouldn't put that in the plus column for a sort of fair, impartial, and informed juror who says they get their news on Twitter or X and Truth Social. But there are also a lot of people who say, look, I watch MSNBC and Fox, and there are things on Twitter and on X that are from reputable news organizations. I post on Twitter. I'm not saying I'm a news organization, but MSNBC and CNN and the Wall Street Journal and the New York Times and lots of other publications post on Twitter. So, I don't want to project the best case scenario here, but somebody could say, yeah, I look at all that stuff on X. I also look at Truth Social because who's not interested in what Donald Trump is posting? And I can discern fact from fiction. But here's the thing, Brian. Just because a juror says, this is where I generally go each day to see what's going on in the world, X and Truth Social, that does not disqualify somebody from sitting fairly and impartially in isolation, as long as they can say, look, regardless of how I absorb my news or try to keep myself informed, what I pledge that I can do, Your Honor, is look at the evidence in the case and make a decision based only on the evidence that is presented to us, not based on whatever is going on X or Truth Social or on Fox News or on MSNBC or CNN. So, no one answer in isolation disqualifies a juror. So I'm hoping that the balance of the answers that particular juror gave the prosecution a comfort level that, okay, perhaps not the ideal juror, but they've otherwise said enough things that satisfy us that they can be fair and impartial if they're selected, to serve on the jury in this case.
Right. I'm kind of leaning on the fact that these prosecutors had the ability to preemptorily strike any jurors that they didn't think could sit and give an impartial view of this case. And the fact that they didn't strike this juror, I'm going to perhaps naively, but just assume that they knew what they were doing by virtue of leaving that juror on the jury. So with that said, we will continue to cover the entirety of this trial as it continues to play out. For those watching right now, if you want to follow along with the Trump trial that's happening in Manhattan right now, please make sure to subscribe. The links to both of our channels are right here on this screen. I'm Brian Taylor Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.